Hello. We're frequently getting asked a number of questions from our clients and potential customers, and one of those questions is, how do I sack an employee legally? Now, the first thing I'd say here is that let's not confuse two processes. One process, which is sacking an employee or dismissing an employee for cause. The other one is redundancy. Redundancy is an entirely different process that's focused on the requirement for a role and not about the performance or conduct of an individual. That's an entirely different set of circumstances, an entirely different process, and a separate video to what I'm about to talk to you about. To sack somebody, firstly, you need to identify a genuine reason. So, is it because of their performance? Is it because of continued misconduct? They're constantly doing something not quite right on a continued basis. Is it for gross misconduct, something that's that serious that you have no choice than to fire them? Or is it some other substantial reason? But even with some other substantial reason, you need to provide evidence that has been a continuation of poor behaviour that you've tried to correct. So ultimately, all of those reasons, you have to follow a due process, and that process includes holding an investigation into the alleged misconduct. Once you've conducted the investigation, you've then decided whether or not there is a case to be heard. And if there is a case to be heard, you need to formally invite that individual to a disciplinary hearing. That disciplinary hearing invite needs to contain exactly the detail that you want to put to them, provide any evidence that is relevant to the case, provide them with an opportunity to have a companion present that can be either a company employee or a trade union representative. It needs to be in good time and needs to explain exactly where that hearing is going to be. Once you've done that, you're in the hearing. So at the hearing, you need to provide the individual with all of the evidence again, present them with lots of opportunity to actually give good reason for what they've done, or give counter evidence to prove that they haven't done what you're suggesting. At the end of the hearing, you need to adjourn, and you need to adjourn in order to make a decision as to what action, if any, to take. The more serious an offence, it's logical that you're going to take more time to consider the options. On reconvening the hearing, you're then going to deliver the outcome, whether that's dismissal or something less, or no action at all. If it is dismissal, you're then going to follow up with a re-adjournment to notify the individual that you are going to terminate their employment, and you'll then follow that up in writing with a letter that confirms the fact that they are dismissed, the grounds of which they're being dismissed on, and those grounds, if gross misconduct, needs to line up with elements of your staff handbook or disciplinary policy, and also their right to appeal. They're going to then have a period of time dependent on your policy to actually put the appeal in writing, and then if they appeal, you have to go through that process as well. So that's how you legally sack an employee. Obviously, you have to have cause. It has to be proper cause. You have to follow a process. If the issue is not as serious, then you're going to have to go through a procedure of disciplinary. So you can't just go to dismissal for something minor. You have to go through a first written warning, a final written warning, and finally a dismissal. If it's gross misconduct, then you need to make sure that your policies clearly state what is and isn't gross misconduct. And if that's on that list of offences, or they are aware that what they did has that consequence, then you could potentially fire for gross misconduct, and that is called a summary dismissal. And if you fire for a summary dismissal, then they also negate their rights to notice, either paid out or to work their notice, whereas procedural dismissals, where you've been through first written warning, final written warning, etc., they'll have right to notice. So that's a whistle-stop tour, and any further advice or guidance that you need, please don't hesitate to contact us. Thank you.